Hello. Good afternoon, everyone, and a warm welcome and thank you for your participation for the special session of the Dubai Arbitration Week 2025, Mega Projects, Mega Disputes, Resolving Disputes Across the Italy and the Gulf. On behalf of AMV Legal Consultants, I would like to express our appreciation for your presence and participation. Today's discussion will explore how major infrastructure and energy ventures across the Gulf involving Italian expertise have given rise to complex, high value disputes, and how arbitration continues to serve as the key mechanism for resolving them efficiently and fairly. Before we begin, allow me to briefly introduce our organizer for today. AMV Legal Consultants is an Italian legal consultancy firm duly licensed by the Legal Affairs Department in Dubai. Our firm was founded and solely owned by Mr. Antonio Varvaro, a long-standing Italian lawyer who has been practicing since 1993 and has called Dubai home since 2008. AMV's expertise lies primarily on commercial law and arbitration. Mr. Varvaro himself is an experienced arbitrator listed with several leading institutions including the DAW, the Dubai International Arbitration Center, the Chartered Institute of Arbitrators, the Tribunal Arbitral de Barcelona, Saudi Center for Commercial Arbitration, and the Hong Kong International Arbitration Center. This year marks the second consecutive year of the AMV Legal Consultants, which we are proudly organizing its own event within the framework of the Dubai Arbitration Week, a testament to the firm's growing contribution to the legal and arbitration community in the region. To guide us through the discussion today, I am delighted to introduce our moderator, Mr. Antonio Varvaro, the founder of AMV Legal Consultants DMCC.
Okay. Good afternoon. Thank you for coming, for attending this event. My name is Antonio Barbaro. I am an Italian lawyer. I am in this country since 2008. And when I arrived in August 2008, I had been appointed by the Italian government as legal advisor for the Italian embassy, and specifically to provide legal advices to Italian companies in intellectual property matters. So I refer to trademarks and mainly trademarks, and not only for registration but for any sort of advice concerning also litigation cases for cases of counterfeit and so forth. It was 2008 and Dubai was totally different than now. Actually, the first time when I arrived here was in 2002, because at that time I went to Bahrain for business reasons, professional reasons. And I remember I stopped here for a couple of days, and I can't forget that at that time, September 2002, the Emirates Towers were still under construction. After the Emirates Towers, there was nothing, only few buildings here, there. Now we see what Dubai is. And as Italian community, because I am a member of the Italian community, we are proud to say that we have given a significant contribution to this emirate, this country, for the development of this country. Let me say that about arbitration. Arbitration, we believe that is the natural path when there are disputes regarding overall, not only international disputes, so related to different parties of different nationalities, but also in, for example, in real estate. Real estate arbitration is the best solution for a quick and precise solution of the dispute. Let me say that arbitration is the way how we can finalize normal disputes that the mega disputes that can arise in some contexts. Disputes arise from delays, variation, cost overruns, supply chain disruptions, but are also from differences in expectations. I come from a civil law country, and here there is a significant presence of lawyers, of jurists coming from common law countries. We believe that these differences are a strength. Are a strength because, let me say, that when civil law logic and common law flexibility are together, they learn how to speak the same language. I'd like to say also that mega projects represent an ambition. This is a country where we have seen many times slogan like unlimited, nothing is impossible, unlimited ambitions and so forth. So it's true, this is a country where we are psychologically pushed to try to do something which in other contexts would be impossible. So mega projects represent ambitions. Mega disputes represent the reality. Because actually, when there are mega projects, these are, it's quite impossible to believe that there will not be disputes, differences, and not all differences can be settled in an amicable way. And arbitration represents the bridge between the two. The most important is that the two parties, this is the message before introducing you our guests, the two parties are have as a mindset that even if the dispute is only a transactional step of the life of the two parties, because at the end you have to preserve the good relationship to go ahead, because maybe next time the two parties will be again partners. I'd like to now to introduce you briefly our guests. Our guests, before that, I'd like to say thank you to to someone. First of all, let me say to you, because for coming here, for to my team, because actually I am the let me say the sole proprietor, the owner of this legal consultancy firm. But those who arranged this event are the members of my team. So to Christine, who is the future of my office. Christine is a student in law here in Dubai at the Middlesex University. Mila, the team manager, Marjorie, and everyone. And to our guests, Rodrigo. Rodrigo is the one who is actually responsible for this event, because I remember in the month of July I was in my my country on the beach under the sun, and so I received an email from a DIAC who said, look, the deadline to present is very close. So I contacted immediately Rodrigo, who is a friend of mine, and I said, look, what can we do? Yeah, we can arrange. He is an enthusiastic young lawyer. Rodrigo is a senior counsel at Galadari Advocates and Legal Consultants. He is a rising star, let me call him like this, in international arbitration and cross-border disputes. He has also a master's in law, which he gained at the New York University. Georgetown University, anyway, in the US. His global perspective and active role in the arbitration community bring invaluable depth to our discussion. Eduardo Ricci, my left. Eduardo Ricci is a manager, human resource business manager at Swiss Boring. Swiss boring is for us, for the Italian community, is an example. They arrived here. Originally, the company was a Swiss company. That's why it's Swiss boring. After that, it was acquired by a group, Trevi Group, which is one of the most important group in Italy, making infrastructures, big infrastructures in Italy and worldwide. That's why the name is the same, but the company is Italian. Swiss boring, I have seen, because I am the owner, which I represented the Swiss boring in different cases, not only contentious, even non-contentious matters. Swiss boring, the license is 1972. 1972. Let me say, his manager told me when we talked a while ago about that, said we have made half of Dubai, because half of Dubai we've been a protagonist. Okay. He will give us a testimony about this some matters related to big projects, exactly, about big projects and arbitration. Carlo Marmo is advises is an advisor. He works at Mastercard. Is a senior legal counsel at Mastercard. He has a unique ability to connect the legal insight with the business strategy and adds an important corporate and innovation-focused dimension to the panel. Last but not least, that's Justin Alexander Gambino, legal director at DAMAC, will bring an extensive experience. He has an extensive experience in major construction, real estate, data center project worldwide. His background in top-tier international law firms, he has worked for example, Bonelli Erede, if I remember properly, no? Which is one of the most important law firms in Italy. They have also an office here. And his contribution to thought leadership make him a strong voice on complex commercial and arbitration matters. At this point, we can start with some questions. And our guest, I am very grateful to them again. Will reply. And I'd like to start with Rodrigo Carre. In the UAE, the legal infrastructure is pretty unique. We have onshore civil law courts, but also DFC and DGM courts operating on common law, plus arbitration centers like Dubai International Arbitration Center and ADGM and others. I don't want to neglect anyone, but there are others also in Abu Dhabi, in Ras Al Khaimah, and so forth. These institutions are relatively young. I think that we can agree on that. If we compare with the ICC of Paris or the London Court of International Arbitration, about ICC, I turned already 100 years. I don't remember the London Court, but maybe more or less. Chartered Institute of Arbitrators. I am a chartered arbitrator, and I remember that turned 100 years in 2009, so even a long time ago. Comparing to these arbitral institutions, the local arbitral institutions are relatively young. Do you think that Dubai and even other institutions in the Gulf are truly equipped to deal with that level of complexity? Because here the disputes are related to big projects. So do you think they are up to solve these cases or not yet?
First of all, thank you, Antonio, for your very kind words and introduction. And I think it's great to have colleagues here and talk about these topics, which are of great concern for Italian companies, international companies operating. Do we need a microphone? Can you hear me? Yeah. That's a bit of an overkill, right? Yeah. So is the UAE right? Put yourself in the mind of those people back in the 50s that started a little place in California called Stanford University. They must have thought, what can we do? You know, go to the East Coast. There's Harvard, there's Columbia, there's Georgetown. Who are we? We're never going to be anything of significance in that world. And look where Stanford got today. And if you go back in time, again in the US, go back to those settlers in Boston, in New England, who must have thought, who are we? How can we compete with the might of the British Empire or the Ottoman Empire at the time? Will this ever be an important legal system in the world? Will we ever have an important financial center? Look what they got. So my view is being new does not mean being inadequate or being less significant than others that might have, for historical reasons, a better track record. But I think the achievements that this jurisdiction has made already are astonishing. I think there is no other place in the world where we sit right here downtown. If you cross the road, you go to essentially another country, which is called the Dubai International Financial Center, that is governed by very different rules, the rules of common law, as Tony said, and where the official language is a different one. So in the definition of the former Chief Justice of the DSC courts, the DSC courts are a common law island in a civil law ocean. And if you drive 2 hours south, you find another country, which is the Abu Dhabi Global Markets. So, these are just 3 jurisdictions within the same countries, and let's not forget, there are 7 Emirates. So as I learned when I was a student in the US, competition is the soul and is the driver for change and for development. And the beauty of this country is that institutions and the Emirates and the various agencies of the state compete with each other to be better and better and to be more competitive. And if you look at the case law, the DIC courts has increased year on year by 38%. 38%, which brings it very close to the New York Southern District and to the English Commercial Court. According to the Law Society rankings that were published 3 months ago, the DFC courts now rendered 125 commercial judgments every year, whereas the English courts have rendered 180. So not so far. So I think the DSC course is getting there. Probably what this country needs, and I go back to your initial remarks about presence of common law lawyers, I think this country needs a bit more diversity of thinking and cultural diversity. That is for historical reasons, because as you know, all of this region, the Emirates and other countries in the Gulf were part of the so-called crucial states because of the truce with the British Empire. So there is a traditional idea that here either you are Arab or you're British, and right. So there is no middle ground. But I think and we see that. So there's a news of yesterday. There is a case, this is public. There is a case involving the Russian Federation in the DFC courts, and a judge, Judge Shamlan Al-Samoleri, was challenged because of his alleged closeness to Russia, which of course everybody might have his ideas on whether or not that challenge was justified. And the problem is that they gave an alternative an English judge, right? So why? Because there are no other nationalities. So I think what Dubai needs to do to get to the next step is look at other places in the world, because there are Italian companies, there are Japanese companies, there are American companies are coming. So that's the next step. And I
Thank you, Rodrigo. I'd like to ask a question to Justin Alexander Gambino, who is manager of DAMA. Justin, in contracts for large infrastructure project, arbitration is the preferred method for dispute resolution overall when the two parties come from different jurisdictions. As the Gulf continues to experience a period of unprecedented growth, foreign contractors are eager to break into the market and therefore often willing to accept the contractual terms imposed by employers, including arbitration seated in Dubai. The question is, what concern, if any, could the foreign contractors have, and how would you respond to them?
First off, thank you, Antonio, for inviting me to Rodrigo as well. I think it's a valid question. I think if you're a foreign contractor coming into your jurisdiction, the two main concerns you're probably going to have are, one, you want to make sure that your arbitration clause is valid and enforceable in the seat that you designated in the contract, and two, that once you get a favorable award, it's valid and enforceable and won't be set aside, and you essentially have to start again. So to answer your question when it comes to the onshore Dubai Sea arbitration, I think 10 years ago, these concerns might have been somewhat valid. But today, no. Because especially after you have the enactment of the federal arbitration law, which is basically the international model law, and you have the court system, which is very pro-arbitration, as Rodrigo also mentioned very briefly, I don't think these concerns are really valid anymore. In fact, I think you see this in practice. Anyone who's been practicing arbitration here, especially any court-related jurisdiction, will see that the courts have become increasingly pro-arbitration. I've seen cases personally during my time here in which counterparties have tried to circumvent their arbitration clauses by going straight to court, naming third parties who are not parties to the underlying arbitration agreement, and the courts, correctly in my view, have declined jurisdiction. So we're definitely seeing a very pro-arbitration environment here in Dubai. One thing I will say that's very important still to this day is these kinds of formalities. So even though Dubai as a whole is very pro-arbitration, it's very important that the person who's signing the arbitration agreement on behalf of the counterparty has the right to this verdict. And you need to check this in one of two ways. Either you make sure that they are a licensed manager on the trade license, under the law they have the authority to bind the company, or also very important, you make sure that they have a POA or you the Articles of Association. But it's very important to make sure that in the Articles of Association or in the POA, you have that express language that says that this individual has the right and authority to enter into an arbitration agreement on behalf of the company. I think that's very important when it comes to jurisdiction. Now, moving to enforcement again, as I mentioned, the federal arbitration law is based on the international model law, and therefore the grounds to really challenge an award are linked to those specific ones on procedural grounds. So I don't see too much concern there. The one, I would say, ambiguous area might be that there is a provision in federal arbitration law that says that the court can set aside an award if the award is contrary to public order or the morals of the state. Now, this is a bit of a vague term, and if you look at the case law, what we've seen is essentially courts generally are hesitant to set aside awards on this basis, but two things that I would say in practice are very important. One, make sure that the witness giving evidence in arbitration, whether it's a fact witness or whether it's an expert witness, that's one approach. And again, a very, let's say, potentially archaic requirement here is that the arbitrators sign the award on each and every page. These are things which I think are important to make sure that the award is safeguarded in the legal challenge. And just to answer your question, I'm an Italian contractor considering arbitration in Dubai against the local entity. I think strategically makes sense.
I do apologize to interrupt, but all of you need to use the microphone because we have a video, and we're gonna publish the video, especially those topics that you are discussing. So, yeah,
No problem.
thank you very much.
So what I was saying essentially is
Yeah, it just needs to be. You have to press it. Yeah.
Okay, sorry. Okay, so what I was saying essentially is that if I'm an Italian contractor contracting with an Emirati-based company, and I have to choose between the seat, whether it's an Italian seat arbitration or a Dubai seat arbitration, I would probably suggest the Dubai seat arbitration. One, because like I said, it has a pro-arbitration framework. But two, strategically it makes more sense. If you have an arbitration and you're successful in Dubai, the recognition enforcement proceedings here are very straightforward. Because at the end of the day, the most important thing when you have an arbitration award is the need to enforce. Conversely, if I had an Italian state arbitration, I would have to, one, litigate my case there, and then take the award and come enforce it here anyway. So strategically, I think it makes more sense to agree to a Dubai state arbitration. So, thank you.
Thank you. Thanks a lot, Justin. I'd like to ask Eduardo a question about recent judgment of the Supreme Court 657 of 2025. I think you know the content of this judgment, of this ruling, and in your opinion, I'd like to know if this judgment has strengthened the position of construction companies operating in the UAE and why.
Thank you, Antonio, first of all, for the invitation on this meeting. It's a pleasure to take a part to this event. Since I'm going to represent a construction company, I would like to underline that one of the topic of our business is to mitigate the risk of litigation and how that it could impact in our activities. One of the main topic, I think, that is the way to consider the importance to go with arbitration in comparison with start a legal action with a local court. So one of the point of weakness of the arbitration is the, especially in the UA context, is the impossibility to, or the absence of full autonomy to issue interim measures or including anti-suit injunction in autonomy. And based on this last Supreme Court sentence, we have the chance that according to this, there is the chance for the arbitration to issue interim measure, including anti-suit injunction in complete autonomy with the local courts. That is, I think, a big opportunity and extraordinary event if after this pronunciation that we are going to have a development after that. Because one of the problem of our business is to avoid that there are parallel litigation in the local courts in the meanwhile there is the arbitration event. And that is a great legal certainty from our side that also represent a protection in against the delay tactics that could interfere in our activities on the project during the meanwhile of the activities. Can we imagine how it could be the financial impact or damage for stop of activities during to the action promoted by legal courts in the meanwhile where that we are in the litigation? And I think that is also an important perspective to start to consider the UAE arbitration institution in comparison to the other international entities like London, Singapore, and Paris, that there are, as an example, a point of reference in terms of reputation for arbitration disputes, and that is reinforced the UA's reputation according after this event.
Thank you, Eduardo. But at this point, I'd like to ask you another question. The practical advantages of this ruling in managing disputes in large-scale infrastructure projects. My question is, what are the practical advantages of this ruling in managing the disputes related to large infrastructure projects?
For sure, we are reducing the impact of the management of the interruption of the works, because we are also reducing the risk of forum shopping. So it could happen that since in our project there are involved a lot of subcontractors that have different nationalities, they could be in autonomy by their own start legal action or legal initiatives that are going to impact the arbitration that is ongoing. And also is in terms of stability, considering a robust clause that give the chance to the arbitration to match the same power of a local court is going to mitigate the risk, the financial risk of all the stakeholders of the project. And even from, since I am HR manager, I would like also to underline that to be involved in the disputes in the mega project, it could be impacting a lot, especially in terms of cost for personnel. In the Middle East area, a lot of our manpower come abroad, they are not local employees. So we are facing very, very financial impact on recruiting people that are coming from different nationality in terms of visa expenses, in terms of accommodation, and without considering all the facilities that we have to put in place to make it is possible that they are performing the work relationship on the project. Can you imagine if we are not facing in a very competitive stool or reputation as arbitration? Can you imagine how is the impact on dismissing all the personnel that we have engaged in terms of number? We are talking even for average of, we can reach a peak of 1,500 employees. And dismissing this manpower force from day to night or to prolong the stop of work during the disputes that is ongoing is something that is impacting a lot. So to have something like that, I think that is very important, and I also consider that giving this power to the arbitration, this chance to the arbitration to match the level of common jurisdiction, give also the chance to improve our contract clauses, especially in the bidding and in the reward activities. And also is very important from our side to make a train of the project manager that is the main, how do you say, manager of the rules, especially in terms of litigation during the project, and also to be very, very clear in the contract to make some to reinforce the clause of the contract. That is very important for my side.
Thank you, thank you, Eduardo, for your clarification. I'd like to ask a question to Carlo. Carlo, as I said, is a senior legal counsel at MasterCard, so very well known company. Carlo, when we think about mega projects, we refer generally to bridges, airports, railways, and so forth. But we have seen recently, and till now, digital mega project with the huge investments in artificial intelligence, smart city platform, hyperscale data center. My question is, how do these digital mega projects compare to traditional infrastructure ones in terms of complexity and risk? And where do you see the greatest potential for disputes to arise?
Thank you. I'm audible, I guess. Thank you so much, Antonio, for the invite. Thank you, Rodrigo, as well. It's great to be here. To your question, before accepting the invitation to come and speak, what's the difference between digital projects and traditional infrastructures? At the beginning, I was of the view that these are two distant realities, and to the point there, I was also doubting, and do I have anything relevant to share with the audience? And I called or contacted Rodrigo, say, Rodrigo, do you think that what can I have that might be interesting for the audience? So I did I believe what any diligent lawyer would have done in my shoes, start talking to colleagues, and I called my Italian colleagues, construction lawyers, local colleagues that deal with this practice. And it gave me a great opportunity to actually come to a very opposite conclusion compared to the one that I was holding at the beginning, which is there are so many similarities and analogies that even now I don't think that there is any specific reason to doubt that these are indeed too distant or too different realities. When it comes from a contract perspective, particularly, I would say, and this is particularly true when we're discussing infrastructure, to the point that there's no better country where this is valid, I believe. The very notion of infrastructure encompasses the digital side of things. If we take into consideration any data center, and I'm gonna drop a term that it's very rare, probably unknown to most of you, which is AI. If we consider AI data centers, there's actually the nature of digital and infrastructure is so interconnected that the AI data centers would not work without its brick and mortar infrastructure, right? And of course, the logic, the heart of the center is not the infrastructure, it's the data that run into it. But the two are so interlinked that there's actually no point in trying to distinguish the two. So back to the questions. Many similarities, particularly when it comes to mega projects. There is a huge aspect of costs. Financial investments required to launch these projects are huge. The time perspective is also very similar. You don't build a data center for it to last a weekend. The aspiration is to build it for generations to come. But the same is true for digital identity systems, right? Governments that launch the projects want to see the projects living for decades to come. And of course, visibility. There is a lot of complexities that go into bringing those projects to life. And unfortunately, when things do not go as planned, consequences are also quite painful. And this is true for bridge, ports, railways, you name it. And this is also true for data, software, any mega projects with a digital side to it. So I would say in short, and I want to conclude by touching upon a very fascinating point that Antonio made at the beginning, when he said, actually, arbitration is a phase of the relationship between the partners. I really love this aspect because even from the terminology that we use, dispute is a combative term, right? There's something that went wrong and now we're disputing. But if you look at it, there's also an alternative way to look at disputes as a more physiological phase of a partnership between parties. That sometimes, go well together and do great things together in harmony, and sometimes do great things less in harmony, right? And it's the same thing as being in a relationship with a non-business partner. It's the same. So I'd really like to conclude by saying that while the arbitration is a tool to protect the relationship, hopefully ensuring that the relationship can overcome the dispute and bring more value to the parties and to the market, the contract is the tool that creates that partnership. And there needs to be the same mindset when it comes to making sure that their architecture that is sustaining the partner is as solid and as protective as possible. And that's the first step to ensure that any subsequent dispute can be solved as a physiological phase in the relationship between the parties. Thanks.
Thank you. Thank you, Carlo. But at this point, I'd like to ask you another question, which is linked to what you said. According to your experience in this industry, which are, in your opinion, which are the mechanisms that could help the parties to reduce the risk of disputes before the disputes materialize, in particular in high-value cross-border projects?
Yeah, thank you. That's very interesting. I would say the first thing that come to mind when it comes to analyzing any contract that is supposed to govern a long-term relationship with digital components is sometimes it's difficult to define what success looks like. So I believe that a good contract is a contract that, as a first step, does a good work in understanding what's the outcome that is expected out of the contract. Sometimes this may be a bit more complex and less obvious than expected. So in my world, for example, even when the contract is drafted in a decent way to define the specs, right? So you buy a car, what does the car do, right? The car runs at 120 miles per month. That's amazing. The car has this super big engine. By the end of the day, the reason why you buy the car is to get you from point A to point B, right? Out of the analogy, what this means is in the digital world is it's fantastic. This platform performs. This platform's uptime is 99% of the time, which means the platform on paper is working pretty much the entire time during any year. But what about usability? Does the platform achieve what is the reasonable outcome that the user expects from the platform? So sometimes there needs to be a bit of focus in understanding the nuances just beyond and in addition to a binary evaluation of is it working or is not working. It's sometimes it's a bit more a gradient. How good, how well is that piece of software working? And there are possibilities to measure that and to draft this into a contract that does a better job in defining what success looks like. And of course, then so many other things that the contract, unfortunately, though, can only accommodate for a number of those. So the contract certainly is a solution, but there's a lot of work that needs to happen between the parties out of the contract and before the contract.
Thank you, Carlo. Let me go back to Rodrigo, and I'd like to ask him technical questions. Sometimes in the list of pro, so the reason why arbitration rather than litigation, there is one simple and banal, if you believe, if you want to call it like that, reason. The reason is that the UAE are members of the New York Convention on Recognition and Enforcement of International Offering Awards. And it means that the awards which are issued in this country can be enforced in one or the other 150, 160, I don't know how many are exactly. On the other way, not all judgments can be enforced because maybe between the UAE and another country, I don't want to mention any because maybe I make a mistake. There is no an agreement on the recognition of the foreign judgment. This is the introduction. My question is the following. In your opinion, on the day-by-day work, are the UAE a suitable place for the enforcement of a foreign award? And by contrast, a foreign an award which is issued in this country, it's easy to be enforced in a foreign country.
So from the UAE outside or the other way around?
Both. The question.
Both. So, well, let's start from the basic. The basic is the UAE has historically been known a place where people and assets were hidden. If you wanted if you had trouble in your home country, this is where you will come. If you were worried about being extradited, that's the place where you will come. If you had billion-dollar creditors, that's where you had your assets. So it was, as other places, another place that had that reputation, for example, is Monaco. And they were both known as sunny places for shady people. But that is no longer the case. The UAE is a party to the Riyadh Convention, which is a treaty involving 25 Arab states, which is very similar to the Brussels I Convention we have in the European Union, so that there is automatic recognition and enforcement of foreign judgments. And the DIFC courts in particular have shown proactiveness in rendering interim relief over assets in support of foreign proceedings. A recent example is a case called Carmo Ristruttura. In Carmo Ristruttura, there was a dispute, a litigation actually, in the courts of Hong Kong between parties from Angola, so no connection whatsoever with the UAE, but for the fact that the defendant had a bank account with Emirates NBD. And that was enough for the DFC court to grant a worldwide freezing order that, for whom is not familiar with the remedy, is essentially an order to a defendant not to move any assets, not to transfer any assets, not to touch those assets, as a matter of preserving those assets for the judgment debtor on the assumption that creditor, on the assumption the creditor might later on succeed. And that sort of relief is difficult to obtain, for example, from the local Dubai courts. And the DFC courts have more and more creative, and that thanks to the common law that allows them to be that creative. In a recent example, it's called Tetian versus Aria, a worldwide freezing order was granted against crypto assets by the DFC Digital Economic Court, Justice Michael Black. That's a judgment from two weeks ago, and that is a first in the world. Another remedy, this has not happened yet in the DFC, but it might happen. It is possible to obtain a worldwide freezing order against unknown persons. There are precedents in England. There is a judgment in the High Court of Justice Cockerill, where a worldwide freezing order was granted against unknown persons arising from fraud, because that's what happens when you're defrauded, right? If somebody clones your card or somebody steals money from your account, you actually, very often you don't know who exactly did that. So something we have seen is actually a shift between the criminal jurisdiction and the civil jurisdiction. So those sort of fraud cases in the past were handled by the Dubai police, the Dubai prosecutor. We find, and we often have clients coming to us asking to raise criminal charges against somebody, And the answer more and more frequently is actually you might actually get a remedy in the DIC courts, because the remedies can be shaped in a manner which is more effective and quicker than it could be through the criminal system.
Thank you, Rodrigo. Justin, I have a question for you. The FIDIC suite of contracts, everyone knows this acronym is Fédération Internationale des Ingénieurs Conseils in French. In English, International Federation of Consulting Engineers. So this set of rules for construction is one of the most popular, not only in the country but also in MENA region. My question is, do you believe that the arbitration center which we have available in this country are, let me say, an appropriate forum for these large-scale infrastructure disputes?
Thank you, Antonio, for the question. So I think after Decree 34 of 2021, the only major arbitration center here now is DIAC. Before we had the DIFC-LCIA, and after the decree, all their caseload was transferred to DIAC. We did have ADCAC in Abu Dhabi, but it enjoyed the same popularity as DIAC. So I think after Decree 34, there was some skepticism as to whether DIAC could take on these high-value construction disputes, especially because the rules were from 2007 and arguably outdated. They didn't address some of the needs of modern construction disputes. But since Decree 34, I think DIAC, by way of example, has taken some very important steps to establish itself as an international arbitration center that can meet the requirements of parties to large-value disputes. And it's done this in several ways. I think first and foremost, the most important thing they've done is they've introduced a new set of rules which came out in 2022. And I think these reflected modern practice. They're very akin to the ones of the ICC, SIAC, and so forth. And I think it's introduced a number of key provisions that are important in the context of construction disputes. So by way of example, under the 2022 rules, you now have articles for consolidation and joinder. I think that's very important because, in these large value, complex disputes between parties and projects, you don't always have just a single contract. You might have a very large project between the same two parties, but it involves multiple contracts, and therefore when a dispute arises between the parties, it's the same parties, same project, and often same issues, whether it's quantum or delay. Similarly, now you have joinder, which is also important and reflects the needs of the construction industry. A lot of times you have disputes that are not just between an employer and a contractor, but you also have subcontractors. And having provisions for consolidation and joinder is very cost effective as opposed to doing multiple arbitrations, which used to be one of the underlying reasons why people went to arbitration in the first place. It was more cost effective. And two, it also prevents, or at least minimizes, the risk of having conflicting decisions. So if you have two disputes over the same project for different contracts, you do run the risk that the tribunal in one dispute finds in favor of the employer, and then in the second dispute finds in favor of the contractor, and this obviously creates a conflict. There are other provisions in the DIAC rules which I think are useful for the arbitration between complex between complex parties. You have third-party funding. Another thing that's very important is cost. So under the 2007 DIAC rules, you couldn't recover your legal fees and expenses, only the cost of the arbitration, and to parties involved in high-value disputes, the legal fees and the expert costs are astronomical. So I think this was an important step. So the rules themselves were the first thing that was very important. Then there's some other changes that were made over the last few years, which I think were very positive. The arbitration court is composed of leading, well-known practitioners here in the region, both from civil law and common law backgrounds, from different jurisdictions. The case management team, when I came here early 2020, I believe it was only 2 or 3 people. Now it's grown to 9. So therefore, the center itself can now take on a growing caseload. And most importantly, I think, together with the enactment of 22 rules, is the arbitrators that are being appointed. So over the last 24 months, we've seen in our disputes that the sole arbitrators and the chair people that are being appointed are very high caliber. And you can see this in the nature of the orders and the awards they render. So when you read them, you can see that they've understand the dispute, they're on top of the cases. And I think at the end of the day, when you're paying so much money, this is the thing that you really want.
Thank you very much. But at this point, I have another question related to the same matter. You are in-house counsel, no? And what advice would you give to in-house counsel prepare for a potential dispute before it even arises?
So I think especially if I were in-house counsel for a company located abroad that's never done business in Dubai, the first piece of advice I would say is know what you're getting yourself into. Because obviously everyone knows Dubai is growing at an exponential rate. Everyone wants to be here. Everyone wants to do business here. The problem is a lot of these people aren't familiar with the realities on the ground. And they bid for projects and they think that they'll underbid and then recover the cost through variations, change orders, extension of time frames, and so forth. And I think that's very frustrating, and it already sets a bad example at the outset of a project. The other thing too is, especially, at least coming from the real estate sector, it's very important for a contractor to understand what the processes are on the ground, who's responsible for the permits, who liaises with utility providers. And I think a lot of time is lost, especially for new people coming into the region, because they're not familiar, and it creates delays, which obviously is bad for the project itself. Another thing which may seem as common sense, but you'd be surprised how many times it happens, is it's very important to make sure you have a very good document database as the project goes. Because in the event of a dispute, you want to make sure that you have a clear understanding of what led you to this point, and if you need to instruct external counsel, that's the first thing they're going to ask you. They need to have a better understanding of how events unfolded so they can best advise you. Something else that was mentioned, I think, earlier today is have a good understanding of their contract. A lot of people sign contracts and they don't know what they're signing to. They think it's just something they put away and they'll deal with it if and when a dispute arises. I don't think that's the right approach. You need to understand, especially in FIDIC, by way of example, if we take the 1987 Red Book, which is still somewhat popular here, there are strict notice requirements for extensions of time, prolongation costs, and if you want to challenge an engineer's decision is a prerequisite to arbitration. These timelines are important. If you miss a deadline, there is a strong chance that you waive your right to these entitlements. And tribunals are more and more willing to enforce these timelines. So make sure you know your contract very well. And then another thing, which is a more recent phenomenon, which you may consider, at least in the construction industry, is having a dispute adjudication board. So under the FIDIC 1999 Red Book, it's introduced this concept of a standing dispute adjudication board. And what this means is you have 1 or 3 members who become familiar with the project at the outset and help guide the parties resolve issues early on, as opposed to waiting to the end where the dispute erupts, the relationship between the parties is soured, and that hinders, the timely completion of the contract. And I think that's very important also because for those people who have been here long enough, the number, although you have many, many companies operating here, at the end of the day, the number of contractors and employers who are involved in the mega gigger projects are not that many. And you will most likely end up working with the same contractor, same employer over and over again. So you want to make sure that you maintain a good relationship, not only for this project, but commercially for the next one as well.
Thank you, Justin. Eduardo, I'd like to step back to the Supreme Court ruling we mentioned earlier, number 657 of 2025. The question is, how does this ruling affect the drafting of arbitration clauses in construction contracts?
As I mentioned before, one of the key points that is impacting after this Supreme Court ruling is to make a more detailed clauses that is going to make explicit reference references to the tribunal power to grant interim measures, and especially in its exclusive jurisdiction. Moreover than this, I think that the trend of the company is to prefer international institutions like DAC, that they are for sure becoming more attractive, because in terms of timing of resolution, for example, if we can make a comparison between to start a legal action on legal court or to start an arbitration, there is a comparison in terms of monthly to finalize the legal action. Is an arbitration, the length of the process is an average of 15 months, and going to the direct or local court, it will require 36 months. So that's something that is very, very impacting in terms of timing frame for the resolution. For sure, the arbitration is very, very short. And in the meanwhile, there are another advantage that sometimes to recruit to legal court, you are people or judge that are not familiar for the specific sector that we are talking about. That is very, very specific. We are talking about infrastructure, construction. And the people that are analyzing or taking care of your case are probably in the local court, people that until yesterday they managed divorce, just to make a comparison. So that is something that for sure it means for us to select the key people that could be manage these kind of disputes, that are prepared, and but also there are some how do you say damage, so that we have to consider some critical aspects that are additional cost. For sure, recurring to arbitration is more expensive, even if the arbitration cost in UAE is lower in comparison to London and the Singapore institution. But in the meantime, we have to consider that arbitration has to keep the matter of the dispute confidential, and that is what is not guaranteed in the local court case, because it's public.
Thank you very much. Let me add something about that. You said that for some specific disputes, maybe judges are not skilled like arbitrators. That's the truth, not because the main reason is that, as you know, it's possible to be an arbitrator, and even if the arbitrator is not a lawyer. So there are some arbitrators who are engineers, for example, architects and so forth. So they have specific knowledge on that specific industry and specific matters. This is, I believe, of paramount importance in the complicated disputes. Carlo, I'd like to ask you a question about the technology as a source of disputes, as you said, as we said. But the question is, do you see that the digitalization, data, international, artificial intelligence reshaping, can prevent or help to prevent, manage, or resolve disputes in large projects?
Thank you, Antonio. Well, first, I love the shift from technology as a, it's probably better if you switch it off, as a source of disputes to technology as a source or a tool to solve of course, disputes in general. There's a lot happening on this front. I'm not how can I say, a big believer in the transformative power of technology. I do believe that technology allows us to focus a bit more on what matters the most. So I do, and probably lawyers in this room will agree easily on this point, I do use massively the various AI tools out there, from Copilot to Cocancel, and I do believe that they do increase, in some contexts, also quite meaningfully, the productivity. I do not, as of now, perhaps future generations will think and see differently, but I do not think that at this point in time we're anywhere near to automatic justice or e-justice or e-judges, however you want to put. I do see in my day-to-day that human judgment is really irreplaceable, right? So the ability to adapt to the constantly changing reality is a trait of human rationality, not of softwares and machines, right? That is our superpower, which is our ability to justify in a flexible, non-mathematic way a certain conclusion. So that's as a premise. This being said, it's amazing, and it's sometimes also a lot of fun to play with these tools that are available out there. What I do see as a potential opportunities in terms of utilizing technology in our day-to-day is providing options to the operators, right? To give a bit more tangible example, what I was playing with just a couple of weeks ago is a software that not only, while you're drafting your nice contract, gives you clauses, like pre-drafted clauses, based on context. So there's some logic that understands what you're trying to do with the contract. And it says, oh, wait, Carlo, you might want to utilize this clause here. But most of the times it's interesting. I do not probably copy paste whatever comes from that, but I do see that these tools are on point. Like, I would probably have drafted something along those lines, right? But better. And so this is one. The other things that I hope will be available somehow is predictive, and this might be relevant in arbitration context, predictive settlement points. So if the machine is provided with a dispute scenario and some prior similar cases, could be case law, could be something similar, then the machine could be utilized to provide the operator, which is irreplaceable, as I said, with options. Hey, do you think that in this context, this solution outcome might be of help? The ability of the machine, which is not human, is the scalability. So instead of providing me with 1, 2, 3 clauses, which is what my brain would come up with in a certain context, have like 15, 20, whatever, you make the number, options. To the point that sometimes it's even overwhelming. That's too much. That's a different problem. So I would say on a contract side, we're still in the future. I do remember early times where I was alone, not with a pen and paper, on the computer already. I'm dating myself. But it was just human, right? So it's me trying to draft the contract. It was the most effective way I knew. So the future is now. I'm never alone drafting. There's always some sort of machine-enabled layer that helps me. From a futuristic perspective and automatic justice, I hope we don't get there, and I hope that the human discretion still maintains its centrality.
Thank you, Carlo. I'd like to ask Rodrigo a question, considering that he works in a very important law firm, a local law firm. So he has an outlook which is significant. Which are, in your opinion, the sectors which might be generators of large-scale disputes? And if there is any special consideration in arbitrating disputes in those sectors.
Yeah, indeed. I think I think there are three drivers of disputes, not just in this jurisdiction but globally. One was mentioned by Carl and Justin. One I think is AI and data centers. Right? We are in a world where everything is becoming dematerialized, and and actually that's where blockchain, new technologies, and constructions interact, because this data centers needs to be built. I understand there are a number of those disputes actually in the local courts, as there is much land that, as we know, is routinely sold to locals, to young Emirati families, that is actually used for data centers, although not always in compliance with the rules. And then, of course, we have companies like the Mac building data centers around the world. So that is certainly a driver of disputes in the construction field and in the financial services sector. We are seeing also a number of financial institutions establishing in the EDGM and in the Dubai International Financial Center. A second driver are geopolitics. There are a number of industries that, due to the international sanctions, have relocated to the UAE. The first one that comes to my mind is the commodities trading industry. Pretty much all traders you could find back in the days in around Souk or Geneva are gone. They're all here now. And those contracts that they were using historically provided for arbitration in Switzerland or probably Paris or London, and today provide for arbitration in Dubai. And we already seen a few of them. And actually it is a public case of the judicial tribunal, the Trafigura case. So a couple of weeks ago is a case involving the jurisdiction of the DAC court in relation to interim measures. So companies like Trafigura are settling their disputes in Dubai. So that's the second development. And the third development, I think, is what arises from the immense relocation of human capital in the UAE. And that is, those are disputes that relates to wealth that has moved, so private clients essentially. Right now at my firm, we are doing the first case of challenge of a DFC will. Never been challenged before. This will be the very first. And obviously there are a number of issues that the DAC courts need to deal with, including the fact that the will service is actually part of the courts. And we have also seen a number of family offices moving to the UAE, and as well-known cases of the last 5 years teach us. For example, the Al Futtaim case. Mr. Majid Al Futtaim left something like $2 billion in assets to his family, and that has generated a number of disputes in and around the region. Clearly, there is a need for those disputes to go to a single forum, avoiding costs and time expenditures for the parties. And again, this is an area where the UAE is at the forefront. That we have a world-class, I think, wills service at the DFC courts. We have a foundation law, trust law, both in the DFC and in the UAE. So that is certainly in other areas where we will see an increase in disputes.
Thank you, Rodrigo, for your contribution. Is there any question? Please, give you the micro.
Probably you can all hear me. Thank you, gentlemen. I listened to all of you with interest. You come from different sort of backgrounds. So a few comments and a question. A lot of what Justin said resonated deeply, because I do work with clients in construction. So the need for records, the lack of notices, and all this sort of obvious things that we all grapple with. But something that you mentioned also in my practice, I was in a large dispute in Africa on a renewables project. It's a massive project. And as you say, the need for rejoinder and conciliation of different proceedings is very important, and it's something that the rules obviously had introduced in 2022, where we had different decisions, upstream and downstream on a very similar kind of matter. So that was interesting to see. On technology, I think, obviously I talk from the construction industry perspective, until all the stakeholders will come together and embrace technology in many ways in the same way, perhaps technology will introduce more disputes than it will help solve disputes. So I think, companies like Damak, Mr. Sejuanis, I think is very keen on all sorts of tech and projects, but the contractors are not necessarily as tech savvy, so there is a bit of a disconnect there. On litigation versus arbitration, Eduardo said, I tend to disagree a little bit because, I've had litigation cases here, arbitration cases, dispute boards and all of that. Arbitration has become very lengthy and expensive. And litigation is sort of picking up, although your point and also what Antonia said, today, perhaps the capability of judges. We are not having TCC core judges here like in the UK, that's clear. But I think...
FC.
Oh, now, yeah, but in the onshore courts.
It's been 6 years.
Yeah, but onshore courts, Rodrigo, it's not quite there yet, but generally it's very quick. I've had 2 litigation cases earlier this year, and it was quick, but yes, the judges... Anyway, I don't want to go there, but you get the point. And a silly question for you, Rodrigo. How, and forgive my ignorance because of it's not my area of experience, in practical terms, how do you enforce that freezing order against what you said, unknown persons? I got very curious about it. How does it work in practice? Thank you.
Well, the point of the worldwide freezing orders by nature have in personam effects. So they don't have in rem effects. So they restrict anybody from doing anything that goes against the effect of the order. So it has a preventive measure. And secondly, they are usually granted where there are assets which are of a known person, but the assets themselves have been identified. So the example is an order of 2019 in England that was enforced over a wallet, a crypto wallet. It was unclear who exactly owned that, but the order blocked the wallet. So that's the whole point of the order. It addresses assets rather than people. And of course, the aim was that as the case went through, but eventually the parties settled, the actual people responsible will be identified.
I'd like just to add something, a contribution. First of all, let me say that I am not impartial because I am a fan of arbitration. But having said that, I am a lawyer, no? So I assist mainly Italian companies, but not only. When they have a legal problem, so I mean a dispute, and or better to say, when we draft a contract and the dispute resolution clause, I prefer to push them to consider many things. Because if we consider the timing, maybe Dubai courts is fast, quick enough, but you have to consider the general cost of that decision. You have to consider For example, that in a local court it is required a local lawyer. We have to consider that local lawyers are, let me say, quite expensive. We have to consider many things, translations, documents, and Arabic, and so forth. Arbitration, maybe if the company is medium-sized or big company, they have a legal office, legal department inside, they can manage the arbitration by themselves. Maybe with a small support external if they need. So I think that at the end of the story, litigation, arbitration is not is something which should be decided case by case, referring to the parties, referring to the disputes. For example, in our country, in Italy, arbitration is not very popular. Why? There is one reason. First of all, there is a let me say, ideological reason. Italy is a country very referring to the state, and so people trust more the state court than arbitration. Who is arbitration? Who is Rodrigo? Who is Rodrigo? Rodrigo is a lawyer, no, he's not a judge. Let me say, Rodrigo is for me like my younger brother. No, so. And let me say, so there is no, people don't trust very much. But there is another point. Arbitration is expensive. This is for sure. That's for sure. Okay, I don't want to go, I prefer to stop because Eduardo asked me to reply to something.
I base my statement on average of cases. For sure, there are very critical exceptions, but you know, the context of companies that are operating in our sector are very, very complex. So sometimes we are operating in JV with a different subcontractor, with different nationalities. So there is a melting pot of people involved. So to have something that is in exclusive way the main path to solve the controversial aspects is for sure, in my opinion, based on statistics, the best way to mitigate the risk.
Thank you, Eduardo. Yes, I am going. Yes, please.
Hello, everyone. It's a pleasure meeting you all. This is Shada. I am from Riyadh Infrastructure Project Center. I am a regulatory specialist there. RIPEC is a governmental organization. We are responsible about the infrastructure of Riyadh region, including the permitting, violation, monitoring. As we are involved in all of the infrastructure projects in the region, from the beginning to the end of the project, we sometimes came across with the major projects which sometimes require or might include the infrastructure work. These projects are often governmental and have its own jurisdiction and ownership over the surrounding area of the main project. Because of that, the center usually receive a compliance from the contractors that need to start their infrastructure work. Now the center, as we have an overview of all the infrastructure of the region, what would you recommend the center? What role would you recommend the center would have in these disputes? As we want to have a role in this, which should we interfere as a mediator or arbitrator? Thank you all.
The question is for all of you. Rodrigo, answer.
Sorry. Your question is mediation or arbitration?
Yes, exactly.
Well, as you know, this is a region where disputes were settled at the Majlis, right? So for nobody, maybe not everybody knows, right? So the majlis were those meetings or eminent rulers or heads of tribes that they will resolve their disputes in the house of some prominent local leader. And as a matter of fact, that was essentially a two-tier system. So if two tribesmen had a dispute, they will meet at the majlis, and some local tribe leader will try to resolve the problem. If it was not working out, then they will escalate and go to the ruler, and then I forgot the exact word for judges. Yes. So and then there will be a proper court formed by the ruler to settle the disputes. Right. That's how disputes were resolved for hundreds and hundreds of years until the British arrived, and then the British, they brought with them the law and their court system, and under the Trucial Pact between the Emirates and Great Britain, disputes involving foreigners in particular were actually going to the English courts. And that might be where, when I said earlier, either you're Arab or you're British, that's what formed from the view. Or minor disputes are going to the political agent of the British Empire sitting in Manama, in Bahrain. And we see that tradition in construction contracts, right? These clauses that we all hate when you need to wait 2 months to commence something. That's, in my view, that's where they're coming from. They're coming from that tradition, that there was the idea that people will not really go to court, they will try to resolve the problem, but this probably doesn't work anymore in today's world. So I know that there is a great emphasis in Dubai in particular in reinforcing mediation. Recently there was a new law on mediation enacted, but I think, and talking here to my experience practicing in Italy many years ago, when in Italy in 2009 we had a mandatory mediation being introduced. This has happened recently in England. I think the moment you make mediation mandatory, that's where it becomes really useless, because if parties are not convinced, if parties do not want to mediate, they will not go anywhere. And what really matters, I think, is the quality of the mediators. What I think makes mediation not very useful in Italy is that the quality of those sitting as a mediator is pretty low. They come to mediation unprepared. They frankly have no idea. Often they read the file for the first time, and they pretend to hear the case from the part. That's not how mediation works. I had, however, a very successful experience recently with a British, very well known, an English case actually, mediator who flew to Dubai. In 1 day mediation, the parties settled, and we reached a satisfactory agreement for both sides. But we started working on this mediation 3 months in advance, and he gave us tasks. We had to make presentation papers, we had meetings with him. He came, of course, very well prepared. He had his idea of what a commercial resolution will be. So I think quality mediation starts from a quality mediator.
I'd like to add something about mediation. According to my information, in Italy, around 40% of mediation cases are finalized, so they reach the agreement. So it's a huge number. Consider that most of these cases are small cases. Are cases because maybe you bought a fridge which is not working, and so these are small cases. Imagine it, to bring these cases to the courts. So the effect has been to make a deflection of the number of cases. Other questions? Any other questions?
Hi everyone, thank you for this interesting discussion. This is Muhammad Radi from Riyadh as well. I have a question that the created reason, or the reason that we created arbitration, that to limit the time that we have in litigation, but now we are suffering from that. So my question here, what we can do in the currently procedure of arbitration to make the time of having an award is shorter than now, because now people, even in Riyadh or even I think in Dubai now, they are going to amicable settlement or even making more mediations, and the contractor may lose some of his money because he preferred to the cash flow and he have an award as fast as he or it can. And so, in one word or two words, I don't know how we can change the current arbitration procedure to be shorter than now. Maybe we can use an AI. Thank you.
I have a comment on that. So I sit as arbitrator, and I was recently appointed by DAC in a matter worth 56,000 dirhams. There was a dispute between real estate brokers regarding a commission, and as we all know, DAC has special rules for so-called expedited arbitration. So if a matter is worth less than 1 million dirham, essentially the arbitrator has special powers to make the arbitration quicker and more effective. The reason why arbitration lasts so long, and I tell you, I had an experience of an arbitration involving sovereign that lasted for 12 years, but that of course was a very high value arbitration, is the so-called fear of breaching due process, right? So as arbitrators, we are overly concerned about making the process fair so that the award will not be challenged. But if the rules, if the parties confer to us the power to make the process expedited, as I did in this case, then parties can get a pretty good result. So in this case, I delivered the award in 3 months. And actually, I had to prepare the award in 2 months, because under the DAC process, they want 1 month review. So actually, I had only 2 months to hear the case and draft the award. And the way I did it, we have no hearing, we have no witness evidence, no expert evidence. I was, you could say, pushy with particularly with the respondent that was absent in ensuring that the process was participative enough. So I think the answer to your question, you know what's the only problem with this system? That is limited to 1 million dirhams, I think is low. At the ICC, it's 2 million euro. So I think they need to bring it up to 10 million dirhams, because really it is not worth to spend too much time on such small disputes.
Thank you, everyone. I just have one comment talking about speedy process and dispute resolution. I think what we lack here in this region is age education. I think it's very common in the UK, in Australia, and it's very quick. It helps the cash flow, especially that's the major issue where the contractors face is cash flow. So I think if it becomes more mature and popular here, things might start to, people will be more satisfied, I think, in Riyadh as well. So just a comment.
Hi, thank you so much. I would say exactly the same. I've got UK experience. So if you have worked in the UK, adjudications have a 28-day limit that obviously can be extended to 3 months if the parties agree. It is a tested system. It was extremely successful in the UK for the last 20 years. It can be vast. I think UAE can vastly benefit from this kind of system. Obviously, it's not ideal, and it's not the lawyer's favorite. But definitely, I think it's not a solution for everything, but it's a solution for many different issues. Even claims of 50-60 million pounds have been adjudicated very, very successfully. You will find the solution in 2-3 months. And something else that you said before is about DRBs. DRBs are useful, but sometimes the whole process is like an arbitration. It's very costly. have expert witness, everything. So even though DABs were made to be flexible, sometimes this is not the case.
And if I could just jump in, I agree with you. The adjudication system in the UK is very effective. It's pay now, fight later. And I think that's very beneficial to contractors. It allows them to, fund the works and make it to the end, and then any dispute is resolved at the end. Whether it could be introduced here, I think it's an interesting question. I don't know how much appetite employers would have for this, for obvious reasons. Contractors obviously do. In terms of DABs, I think it's picking up now. It's not as popular. It wasn't as popular, I'd say, 10 years ago. Again, it's really on a case-by-case basis. I think if you have a standing DAB, like I mentioned before, it might be beneficial, especially for those long-term projects where you want DAB members to be familiar with the project and the potential issues at the outset. But yes, I can agree with you. It's only effective if it works. And a lot of times you end up in arbitration anyway. So, but even again, it goes back to arbitration itself. Arbitration is an effective tool, but it also has its drawbacks. And as we discussed today, some people even insinuating that litigation might be a better option. So it depends.
Any other question? Please.
My name is Devidas Nayak. I'm an independent expert. I'm working in the Middle East for the last over two decades. I worked in the mega projects. Just now I heard there are some instances where the award is delayed over 12 years. If one of the party is a foreign entity, can they not invoke investment treaties? And if so, can you share your experience on this, if there is, in the Middle East?
I'm not aware of. So in this particular case, have you already obtained an award?
No, I mean there is a delay in award, for instance. Like you said, just
but have arbitration proceedings pending?
Yeah, pending for over 12 years, or 9 years, 10 years, whatever number of years.
And the counterpart is a state entity?
Let's say one of the party is a foreign entity, I mean not in the country.
Yeah, but it depends if the other side is a state entity, because if it is a state entity, then there is an act of state. If the counterpart is a private entity, I don't think you can invoke any treaty. If you were in court, probably you could invoke some kind of denial of justice, also under the charter. Yeah, but why you didn't challenge the arbitrators if they're so slow?
No, I'm just asking. It's a general question because I have read some instances where the private entity went back to their country and approached the government because they are not getting the justice.
Yeah, but
there is a court intervention, and because the arbitration law in every country is different. I mean, there's some countries they allow court interventions during proceedings. Do some procedural or local laws.
Yeah, but you need to invoke the courts. You should just sit and wait.
Yeah.
You cannot raise an investor state claim. There is an example actually from Italy, which is the Enel case. Maybe some of us read about it. So in the Enel case, a very, very well-known Italian professor was appointed as co-arbitrator. And during the proceedings, the other side discovered that this very well-known arbitrator and professor was also sitting on the board of one of the subsidiaries of one of the parties. That's an obvious conflict, which he had failed to disclose. Because this was an ad hoc arbitration seated in Rome, the other side went to the courts in Rome, and under the old arbitration law, there was no remedy at all. So they went all the way up to Court of Cassation, and they obtained no relief. The court said, sorry, we have no power to remove this arbitrator. So what did they do? They went to the European Court of Human Rights. Eventually, the European Court of Human Rights ruled that yes, this was a denial of justice, and Italy was in breach. But you see, they went to court. They went to court. So unless you engage an organ of the state, which could be the courts, you can only raise treaty protections.
Unfortunately, we have reached the end of our event for today. Again, I would like to thank our panelists and for you, Mr. Rodrigo, for helping us organize for this afternoon's event. Can you guys join me into appreciating our panelists for this afternoon? And also thank you for our audience for helping us to have a productive discussion this afternoon. Again, we are proud to have contributed to the Dubai Arbitration Week 2025 for the second consecutive year, and we remained committed to fostering meaningful dialogue between the Italy and the Gulf and the wider international arbitration community. Thank you for being with us today, and we wish you an enjoyable and productive continuation of the Dubai Arbitration Week. Sorry, we would like to have a photo with everyone. Is that fine? Yeah, thank you so much. First, we're going to take a